and in context of today, what to do if you are caring for someone else, what are some of your rights and obligations, and as we see in the news, how to address and deal with the growing epidemic of abuse and exploitation. So I wanted to first get into something that a lot of people are not familiar with under Florida law, and it's a statute that is somewhat unique in the United States. Remember, despite what we see with TV and news and a lot of movies out there, issues related to elder law are extremely state specific. So something going on in North Dakota could be entirely different if that case or family lived here in Florida. And one of those things that I think is very interesting, and one of the reasons why we talk to our clients about signing a document called a designation of healthcare surrogate, is this statute right here that I have highlighted and scribbled all over for you. It's called the proxy, but it's really in the biz, we call it the healthcare proxy. This is a person that the Florida legislature has designated to be someone who can help stand in and make healthcare decisions if you are incapacitated. And I'm not going to get into the nitty gritty about the legal side of incapacity right now. I will when we talk about a little bit about exploitation, but incapacity, remember, could be something as basic as you are going in for a routine colonoscopy, you're under general anesthesia for a few hours, you're unable to make decisions. But when you come out of your anesthesia, you're able to make decisions again. Someone who may have had a stroke, who might have permanent damage and may not be able to make decisions for the rest of their lifetime, that is another form of long-term incapacity. And that's where a proxy can stand in. The legislature wanted to make sure that someone in Florida could help make decisions when you and I are unable to make those decisions for us. And I highlighted some key parts in the introduction of this law here, because this is pertaining to a person who has not executed an advance directive. And an advance directive is a document like a living will or that designation of healthcare surrogate, which we're going to talk about today, that says, today, I, Max, I have full capacity, have decided that Victoria should make my healthcare decisions if and when I'm not able to do so. So when I don't have that document, the legislature has created this order of individuals who can help make decisions when I'm unable to. And the first person here, and I've just tried to clarify this to make it easier, is a court-appointed guardian. And if a guardian is unable, or if there isn't a court-appointed guardian, the next person on that list is the individual spouse. And you can see where this is going. It's the next person after that is an adult child. After that, it's a parent of the individual, then a sibling, then any other relative, like an aunt, an uncle, a cousin, even going down to a friend. And then finally, even a clinical social worker who has met special licensure and works at, typically in this example, at a hospital or other type of medical facility. So the reason this can sometimes be an issue is a very basic real world example. Just this week, I did some estate planning for an individual who was in the process of getting divorced. She wasn't divorced yet. And so her concern was, what if she were in a car accident and she didn't have a healthcare surrogate, and the first person on her list to help make healthcare decisions for her if she needed surgery, if she were under anesthesia, is that spouse, that husband that she is in the process of leaving. What happens if you are a child who just turned 18 and you may not have a significant other, you don't have your own child, and you have parents? What happens if you have a poor relationship with your mother or your father, or both? What if you've been estranged for years? All of a sudden, a person who you may not want to be in that position could be making healthcare decisions on your behalf. And the next issue really is, who is actually, of all these different types of people listed, who is actually available? Because maybe you do have a parent, but the parent is not actually available or doesn't want to make healthcare decisions. So this statute, while good because it establishes some type of protection for an individual who can't make healthcare decisions, doesn't necessarily give you full control and doesn't let you necessarily explicitly state whom you want to make those healthcare decisions for you. And I'm going to move on a little bit because I have a lot and I know I can talk a lot. But I want to move on to solving that problem. And if you'll notice, and this is where we talk about that healthcare surrogate. And if you notice when you review this, I've highlighted you a lot of times because I'm sure some of you are like me. We're very type A. We like to keep control, even if we can't make a decision right in the moment. And so I like having a healthcare surrogate and a power of attorney, like Victoria will discuss in a little bit, because you get to decide who can make decisions for you and with you if you're unable to do so. So instead of that default statute that we just discussed, I can designate someone to make decisions. And I want to talk briefly about those decisions because this part can get a little confusing and sometimes, a little nerve-wracking. When a person, your surrogate, let's say your spouse, a child, a best friend, an aunt, an uncle, whoever you may be, is in a position where they need to work with your doctor, work with a medical professional, that person is standing in your shoes when making directives or speaking to that physician. So the example that I always like to say is, if Victoria is still my healthcare surrogate and she knows that my favorite color is blue, but her favorite color is red, if the doctor says, what colored shirt should Max wear, she's going to say, well, I know Max prefers blue, even though I hate it and it's the ugliest color in the world, and red is the best color in the world, but he would prefer blue, so he should wear a blue shirt. And that's very important. So that's something to consider when you are choosing someone to be your surrogate, because a lot of people might say, well, my mom is the closest person to me. She's my nearest blood relative. Well, that could very well be true, but does your mother know everything about you, your expressed wishes, how you want to be treated medically, your healthcare concerns, or maybe your best friend that you've grown up with and went to college with and now you live down the street from, maybe they know you better. And so those are the types of decisions that you can discuss and make in consultation with an attorney to help make sure that you have the best team in place to care for you. So this document is a rather interesting one. The document has a provision that it'll only come into effect if your doctor says that you are unable to provide that informed consent for healthcare treatment. And of course, there, as you guys can see in that bold and italics, like everything in the law that annoys everyone, there's always an exception to every rule. And for the healthcare surrogate, when you sign and execute the document, there's a provision in there that says that you can actually give your healthcare surrogate the right to access medical information, your file at a primary care physician or any specialist, and to help make decisions for you, even if you have sufficient capacity. A lot of people like to do that so that they don't have to go through the process of having a doctor actually sign off on whether or not the individual who is executing the document, which is also called the principal, has capacity or not. So I talked about this provision already, but there's more interest in more information in there too. So let's talk about what actual decisions a healthcare surrogate can make, because it can be a bit more than most people think, because that name healthcare might be a little bit of a misnomer. So if you're incapacitated, whether a doctor says you're incapacitated or even a court adjudicates you to be incapacitated, your surrogate is able to make medical and mental neurological healthcare decisions for you. That means speaking to those appropriate doctors, speaking to other caregivers, arranging that type of care. They can also determine your residence. If that means, you're living at home, but you might need some support and an assisted living facility meets your current level of care, they can arrange for you to move into an assisted living facility. If you have injured yourself and you need temporary rehab, they can help sign you into a rehab facility and sign you back out and bring you home. They can even access your financial information for specific purposes of applying for different types of public benefits that help your healthcare needs. I said access because they're not necessarily, this isn't your power of attorney, but they can get statements because, for example, if you are going to apply for Medicaid in Florida, you need to show the state of Florida your account balances. So in order to do that, your healthcare surrogate can obtain those statements from your different banks or financial advisors. And most importantly, they have a duty to you, your surrogate has a duty to you to always be informed of your current healthcare needs, your current state, so that they can make the best decision possible, looking at the combination of what your wishes are, what your care is, and what you need at the time. So a few little specific questions that we get all the time in consultations. Can you have more than one surrogate? Yes. If you're someone my age, you are pretty likely to designate both of your parents as a surrogate once you turn 18 and mom and dad can't make decisions for you anymore because you're an adult, even though we like to deny it. Now, you can, depending on what you speak about and your wishes, your attorney may advise you about different ways of handling having a majority. So for example, if you have two surrogates, using that example, they may have independent authority and they can act on their own Typically, we advise that, or some people prefer that if they have 2 or even 3 surrogates, that they have to act together and make a majority vote. I think you can imagine how that could be problematic in the real world. One, assuming your surrogates might have a disagreement, but 2, the practical reality of you have an immediate healthcare emergency and you might not be able to contact all 3 of your surrogates to vote on how to handle something. But most importantly, whether you just have 1 or 2 surrogates, we always recommend that you have an alternate. And you can name 1 alternate, or you can have an entire list of alternate surrogates. And when we mean alternate, we mean if Victoria is unable to serve, or she refuses to serve, or maybe she is incapacitated herself, then I might list my other boss, Mary Wakeman, as the alternate. And when Victoria is unable to serve, Mary will succeed, and now she will handle all of those rights and responsibilities and obligations as my surrogate. No, my surrogate does not have to be related to me. I can nominate my bosses. However, something that we do remind our clients a lot that they may not always think of, whether you're nominating your spouse, your child, your best friend, your boss, you may want to actually tell them that you're going to do that. Because you might want to ask them, because we have had situations where a person has nominated a grandchild to serve as healthcare surrogate, and then that grandchild comes to us and says, "Grandma never told me about this. I don't want anything to do with this." No. And grandma might not have designated an alternate, and now there's no one to make healthcare decisions. What happens in sort of the bad case scenario, the worst case scenario, and this is sort of leading up to our exploitation section. What happens if someone disagrees with what your surrogate is doing? An interested person, and an interested person could be a family member, next of kin, can petition the court for an emergency proceeding to review what's going on, to review that act. We have had that situation. We've had situations where family members have even tried to remove a healthcare surrogate for various different reasons. It's pretty rare, it's pretty uncommon, but it is a possibility, something you should be aware of, and something that you should consider discussing with your attorneys. Next thing I want to talk about is a living will. So a living will gets confused all the time because it's, once again, we named it incorrectly because lawyers are not creative and we don't think about things like that. A living will is an end-of-life advance directive where you state your preferences when you have reached one of 3 different types of conditions, and this has been determined by state law. The first is a terminal condition. The second is an end-of-life, an end-stage condition, or if you are in a persistent vegetative state. Your living will can determine, your preferences of whether you want to be kept alive via artificial means, such as a feeding tube or a respirator, or if you don't want to be kept alive artificially. Key thing to note here, if you don't have a living will, but you have a healthcare surrogate, your healthcare surrogate can make that decision based on their knowledge of your preferences. Now, we recommend that you, at the same time you're in our office signing a healthcare surrogate, you also execute a living will so that you are clearly establishing and maintaining your preferences on how you want to be treated at an end-of-life situation. Last thing, because this is the question that always comes up when we do estate planning consultations, a living will is not the same thing as a last will and testament. A last will and testament is a separate document for probate purposes that just discusses how you want any of your personal property, your financials, anything like that to be distributed after you die. A living will is about you when you are still alive and how you want to be treated if you are in one of those terminal end stage conditions that we just discussed. So I'm going to skip, and Victoria, how much time do I have to get in to do exploitation? Don't think she heard me.
Had to unmute.
Okay.
You've got 5 minutes.
Okay. So exploitation is, I'm gonna get it all in a nutshell. Exploitation is on the rise, not just in the United States, around the entire world. For the many obvious reasons, we have the largest aging population globally. We have the largest concentration of wealth in one generation in human history. The transfer of wealth over the next 2 to 3 decades will be the largest transfer of wealth from one generation to the next. People might not be aware of those statistics, but people see it. And as a result, exploitation is on the rise. And that leads to exploitation, meaning something as basic as stealing money from a vulnerable adult's bank account, or even committing physical healthcare abuse. A vulnerable adult is an individual who has some type of morbidity, such as Alzheimer's, dementia. It can be a physical condition, such as a hearing deficit. They may be blind, but otherwise have full neurological capacity. And I wanted to go over a few tools in Florida that actually makes our state one of the leading edge states in the country to protect its citizens against exploitation. The first is a law that came into effect in 2018, so relatively new. Our firm was we were the first to actually successfully get one in court. And it is an exploitation injunction is the layman's terms, but it is an injunction for protection against exploitation of a vulnerable adult. You can see why we call it an exploitation injunction. So what this does is, if a person if a vulnerable adult themselves, or a specific type of person, such as a guardian, such as a guardian, or even Department of Children and Families through Adult Protective Services, can file this petition, which you see an outline of that we actually created, to ask the court to do the following. The court can freeze the victim's assets, meaning their bank accounts, investment accounts, and IRA. It can freeze an ongoing closing on a house. And it can also, more importantly, in terms of healthcare issues, it can prevent a potential exploiter, a criminal, from harming the individual by preventing them from having access to the victim, or preventing them from going near their property or any location where they may be. And once this injunction is in place, we have the ability now to actually go back and try to take back any money, any stock that's been stolen, and bring it back to the victim. We've been pretty successful with this. I'm going to briefly skip over to a new law that Victoria and I have been working on with the elder law section. The Attorney General and a few other stakeholders have been working with the legislature on a new law that's probably going to pass this session of the legislature, that will disinherit a exploiter. So if someone is either criminally convicted of exploitation or is found in civil court to have exploited a person, but they are still technically listed in their will, if the person for whatever reason is unable to change their will or a trust or a pay on death beneficiary on an account, when that person dies under this proposed law, that criminal will be unable to inherit from their victim. We're really proud of that. In fact, the law just this past week has been amended to also include if that person was convicted of exploitation in any other state in the United States, not just in Florida. They don't even have to be a Florida resident, but if they have exploited a Floridian, when that person dies and they are still listed as the sole beneficiary of an estate, they are not going to be able to inherit from them. The only exception, because of course, like we discussed, lawyers love exceptions, is if there's been some form of reconciliation, something may have changed, and the victim has decided, even though you stole from me, I'm still going to make the decision with full capacity to allow you to inherit. So I realize I talk a lot. So I'm going to pass the baton over to Victoria, who is going to be talking about a way to prevent exploitation, a durable power of attorney.
Thank you, Max. And let me just do a quick shout out to the Alzheimer's Project for having this conference, even though virtual. This Alzheimer's disease conference is so important for our community, and the Alzheimer's Project does an amazing job of making sure people are informed and have access to resources, which is one of the big takeaways I want everyone to have today, which is that, know your resources, know who to call, know when to call, and to protect yourself and your loved ones. So that's really vital. So I'm going to have a little bit less time, which is completely fine because Max took, the heavy weight on the substance of advanced directives and exploitation. I will make a note, Max, I'm not sure if you said this, but that pending legislation in the legislature right now is also going to include a provision that will allow agents under powers of attorney to be a petitioner for these exploitation injunctions, which is going to be important. It's going to give us yet another tool to petition to stop exploitation. Right now, you have to have either you have to be the victim, him or herself, or you have to have filed a petition for incapacity and for guardianship, or actually be a guardian before you can file the exploitation injunction petition. So if you're a power of attorney agent, this will give you one more ability to protect your loved one. So the materials that we have up on the screen, just some general powers of attorney, unlike what Max just talked about with advanced directives. They are something to do in advance. However, they typically do not include healthcare authority. You can have healthcare authority, such as that type of surrogate authority that Max was talking about. You can have that in a power of attorney. But typically, a power of attorney in Florida is going to be primarily for financial and property management. That's really what it's about. And a lot of people will say, well, I'm dad's POA, or, I'm the DPOA or power of attorney. That's fine. I mean, we're all used to that, that vernacular. Under the statute, the person is technically considered an agent for the principal. Max talked about principal. That's a commonly used term for the person that makes the document. I, Victoria Heuler, make a power of attorney for myself. I'm the principal. The person I appoint as my agent will be the agent. Some people call it attorney in fact. That's old language from before the statute was amended in 2011. All of it's good. It all gets to the same point, which is you're acting for someone else under a power of attorney. Now, what's important is that it needs to be a durable power of attorney, because if it's not, If it doesn't say something about durability or surviving incapacity, then if the principal becomes incapacitated, that power of attorney is going to vanish. It will not be able to be used. So it must have that durable or durability language, something referencing this is good even if I become incapacitated. So the law changed back in 2011, which will soon be 10 years coming up in this October. And the big changes were several. There are now requirements for what are called superpowers. And these are special powers that have to be specially listed if the agent is to have those authorities, such as the ability to gift, create revocable or irrevocable trusts, or the ability to change beneficiary designations on a life insurance or on an annuity, or the ability to change joint ownership on accounts or pay on death designations on an account. So they have to be separately what we call enumerated, set out separately in the power of attorney. And next to those superpowers, the principal, the person signing the power of attorney, would have to sign next to that special power, that superpower, or would have to initial. If there's no signature or initial next to a superpower, it can't apply. The agent wouldn't have the authority to do any of those separate superpowers. So, and those are added protections that the legislature put into effect in 2011, because those are some of the powers that can most be abused. So if you're the principal and you gave someone a durable power of attorney, and it kind of just had some blanket language, you can buy and sell property, you can go to the bank for me, you can make gifts, you can do this, you can do that. That's a very powerful document. And one of the biggest things about powers of attorney that's very different from the advanced directives Max was talking about is that as soon as the principal signs the power of attorney, it's immediately effective. Before 2011, there were these powers of attorney called springing powers of attorney. You may have heard of those. And those were permissible prior to October 1, 2011. So if you have one of those, and I've done a few of those for clients in the past, if you have one of those that's dated before October 1, 2011, it's still valid if it was signed in accordance with law at the time. And those would have allowed the power of attorney to only become effective if a doctor said that you were incapacitated. If you tried to do a springing power of attorney today and sign it today, it is no longer available. It would be void. It's just not legal anymore if you tried to sign one today. Older powers of attorney, again, just regular durable powers of attorney that were signed before October 1, 2011, those are still good as long as they were good at the time you signed them under that law, no problem. The only difference to that is you may have seen these kind of long paragraph powers of attorney. They're, the paragraph's about this big and it just goes on and on and on. And that's it. It basically says anything I can do as the principal, my agent can do. Those are overly broad. And so what the legislature has said is that those are so broad that we're no longer going to honor those. Doesn't matter when they were made, because they don't provide enough specificity. So basically, powers of attorney under current law must be witnessed by two individuals, two adults, of course, competent adults, and must be notarized. And they can be used to, again, depending on the powers that the principal authorizes, can be used to effectuate transfers of real property, opening and closing bank accounts, transferring funds, opening, buying life insurance. I mean, just about anything. Again, only if limited by the principal. I have had clients who have very particular wishes regarding their durable powers of attorney. I mean, a lot of the powers of attorney are pretty pretty formatted, but I've had several clients who have done very particular items in their durable powers of attorney and specified certain things that they wanted to make sure were noted or that weren't in there, that they said, no, we're not going to put that in there at all. I don't want that to show up. I don't want my agent ever having that authority. That's perfectly fine. And we, what's real important to us as elder law attorneys is that we sit down with our clients and we make sure that they understand what's available to them, their choices, right? The be aware, what are your choices? That they have control over the process, right? So we don't tell them what to do. We offer them options and we tell them what the law allows. And then we try to help them construct something that makes sense for them. Now, if a client comes to us and says, and we've had this happen very frequently, get a call, the client says, my mom needs a power of attorney. I need to come get one. Can I pay you to do that? Okay, well, unfortunately, no. You, the loved one, can't make a power of attorney for someone else. So it doesn't work that way. The loved one has to make the power of attorney for themselves. So if I get a call from a child who says mom wants to make a power of attorney, I'm happy to sit down and talk with mom. No problem at all. If mom doesn't want to make a power of attorney, or maybe doesn't want to make a power of attorney for that child, then mom's my client. I'm going to do what mom says unless I believe mom doesn't have capacity. And, the child that asked mom to come see me may or may not have things happen the way the child thought they would happen. And that brings up a point for participants today. There may be some of you out there who maybe you have a diagnosis of Alzheimer's or other dementia, or your loved one does, and maybe it's in the very early stages. A diagnosis in and of itself doesn't say anything about your current level of ability to comprehend documents and to control your own destiny. So please don't think that a diagnosis means everything comes to a screeching halt. Sometimes that's the best time to start the planning and to go ahead and get control over your affairs before it gets too late and you aren't actually able to make decisions for yourself, or if your loved one has been diagnosed. So the duties of the agent are extremely important. And again, these are live. The minute you sign them, these powers of attorney are available. So you want to make sure, please, that powers of attorney are given to trustworthy individuals. And more and more of my clients like to do co-agent appointments. So they'll appoint, son and daughter. Sometimes they'll even do 3 people. It can get a little more complicated the more people you add. But we oftentimes, with the client's permission, will allow an agent to act independently of the other agents. It just depends on the dynamic. If the client thinks everyone's very trustworthy, then child A, B, and C can be named, and each of them can have independent authority to do things for mom or dad as may be necessary. Or the principal, the person making the power of attorney, can say, nope, I want to make sure that they always agree. So if I appoint my son and my daughter, they have to act unanimously no matter what. And that, can create problems. I'll talk about that just briefly in a minute, about what happens if you don't plan and prepare, and what can bring you into guardianship world, which, even though I do a lot of guardianships, I do my best to try to talk people out of them and see if we have alternatives. So, but when an agent is appointed and the agent says, yes, I'm willing to act, and sometimes we get the agent to sign off that they're willing to act. That's not legally required, but it can be good practice just so we know that someone is committed to acting on behalf of the principal. And like Max said, we encourage our clients before they name someone to make sure that the someone that they name is willing to act, because not everyone is. You don't want to name someone who's not going to be there when you need them. The agent has an absolute duty to act in good faith. And similar to what Max was talking about with the advanced directives, the agent has to act in accordance with the principal's wishes. Again, it's not what I want as the agent. That is immaterial. It's what the principal wants and wanted, and what I know that they would expect. I'm standing in their shoes, and it's my job to make sure that their wishes are carried out, as long as those wishes are legal and there is no, law that would prevent that from occurring. I can't act contrary to my principal's best interest. I can't act in my own self-regard. I'm there to protect and preserve the principal's resources and make sure that their property is managed correctly. I mean, it's a big job. You know, acting as an agent under a power of attorney is like a trustee. You're handling this person's assets and income and resources and all that. So if you're the agent under a power of attorney and they have a piece of rental property and they're no longer able to manage that and you're doing it for them, you're collecting rents, you're making sure repairs are being made. I mean, it's very much a job, and it can be very involved. And so, again, important to appoint the right person. The agent must keep records of everything, receipts, disbursements. Again, you're a trustee. You have to track everything, because at any time you can be asked by any other interested person to account for what you did, how you did it. So you have to account to the penny without question. And your loyalty is to the principal, again, not to you, not to a third person that you think could benefit from the principal's assets, but the loyalty is to the principal. And again, if you are designated as an agent and you feel like you're not up to the challenge, you have your own issues, or you just don't want to do it, then you should decline. And I would suggest that it's called a declination, that it be in writing and passed around to anyone who needs to know, but certainly the principal, to let them know you're not willing to do it or not able to do it. So if there's a problem with the power of attorney and the agent or agents are abusing their powers, then the best thing to do is anyone who suspects or knows that there's been abuse, neglect, or exploitation is duty bound to call the abuse hotline, which is right there. It's 1-800-96-ABUSE. It's an anonymous call. The Department of Children and Families handles the Adult Protective Services abuse hotline. The caller will remain anonymous. The Department of Children and Families will take the caller's information, but that can't be disclosed to anyone else. And then the Department of Children and Families will investigate within 24 hours and determine whether or not there's been an abuse or exploitation of the principal. If the power of attorney is being used to go around to the banks and empty out the principal's bank accounts, which Max and I have seen on more than one occasion, when a family member that really shouldn't have had the agency authority is given that authority and uses it to loan themselves, to temporarily help themselves, because mom would have wanted it. Mom would have wanted me to buy that new car because, I got to drive. I mean, I have to get to my job, and she would have given it to me if she'd had capacity. So that could be turned into abuse right away. By the way, that's another condition that what we call, lawyers call condition precedent for an exploitation injunction. Before you can get an exploitation injunction, you have to also verify in that injunction, the exploitation injunction petition, that you have called the abuse hotline. That is required before you can request that injunction against exploitation. In other words, you have to use the resources that are out there, as well as accessing the courts for help. The clerk's office, every clerk is required to have the exploitation injunction available for people to use, so that there's no attorney required. And the clerk's office is required to assist people in completing the petition for the exploitation injunction and assisting them with carrying that out. It's a very quick process. It's an emergency process typically. And then the court will have a hearing later on whether that injunction, if the court grants it, should be made more permanent based on, and have a more full hearing. All right, let's see. So if I also included, real quick, Max, if you can zoom up to the tips, there's a two-part outline of the tips for agents if you are acting as an agent. Just again, some guidelines for you. If you or your loved ones have not prepared and not done any of these advanced documents to provide healthcare decision-making and or property decision-making if there's an incapacity, you're likely to end up in the guardianship world. And I handle a lot of guardianships, so does Max. There are these cool things called voluntary guardianships that most people don't know about. And just real quickly, I consider them kind of like a court supervised power of attorney. It's a person who can make their own guardianship. They come to the attorney, they say, I want a guardianship of my property. It's only about property, has nothing to do with the person. They want to have a guardianship over property. It can be just some types of property. Maybe it's just some real estate, and maybe the guardianship wouldn't have anything to do with their bank accounts. Like maybe they think that's perfectly fine. They can manage that, but they can't manage their real property anymore. And it's for people that have mental capacity, and the doctor has to certify that they have capacity, but that they have physical infirmities or infirmities of aging that require the assistance of another person for the management of the property. But it does require the court to appoint the guardian. The person creating the guardianship for themselves gets to choose who their guardian would be, so that's great. And then the court will monitor the guardianship on an annual basis. And so you have access to courts in case something does happen. But it's kind of like a little extra level of protection. It's nice that we have that option in Florida. Otherwise, typically what you're going to see, especially with the elder population, is an involuntary guardianship. So, and Max, if you could move down to that area of the materials. I know I'm getting really close on time here, but involuntary guardianships are when, for the older population, when we have someone who, let's just say, is in the middle to later stages of Alzheimer's, dementia, some cognitive dysfunction, where we have to go to court because we don't have a power of attorney, or we don't have a healthcare surrogate designation, or we have fighting family members. We have, the two people that were appointed, and mom said they have to agree, and they don't agree on anything. The only way to resolve that typically is to head to court, get the court to determine, does the principal now lack capacity? If so, does he or she need a guardianship? And if so, who should that guardian be? Sometimes the incapacity is not really the issue. Everyone agrees that there's a lack of capacity, but the fight is over who's going to be the guardian and why. In Florida, Florida's called a less restrictive alternative state, which means we have to try everything possible not to have a guardianship if we can. So if there is a power of attorney and the agent is doing their job and they're not exploiting or anything like that, the power of attorney can be used rather than having a guardian of the property. Same if there's a healthcare surrogate. Maybe there's a surrogate, but there's no power of attorney. Then we would only need a guardianship for the property because we don't have a power of attorney. So there are a lot of different alternatives, and we want to keep it as small as possible. We can get emergency temporary guardianships in place. Again, sometimes that's necessary if there's exploitation, and we have to do both an emergency guardianship petition as well as seeking an exploitation injunction. Basically, I think those are kind of the highlights. With the power of attorney, if there's ever a problem and the principal still has the capacity, the principal can certainly revoke the durable power of attorney in writing. And by the way, don't assume that a new power of attorney revokes older powers of attorney. It has to say that it does. Otherwise, you might have two competing powers of attorney signed at different times. So something definitely to be aware of. Trissetta, I think we're probably at a good stopping place given the time, and I know you want to get some questions and answers.
Absolutely. So if you do have questions, please go ahead and drop those in the Q&A portal, and we will be sure to get those answered for you. We do have one already in the chat, in the Q&A from Philip Nowicki, who asks, what happens if a person gets an early diagnosis of dementia while still competent and right after executes a DPOA? Then years later, when the person is no longer competent, a third party, for example, a financial institution, refuses to accept the DPOA because it was executed after the date of diagnosis. What could the agent do at that point?
Go ahead, Max.
So this is something we deal with all the time. This is a fantastic, great question, Philip. And you actually already kind of answered your own question, but I'm going to give the long lawyer answer. I sort of briefly mentioned it without really getting into it, but capacity, incapacity, however you want to look at it, is a spectrum, meaning there is no longer, and this is again something, we can be proud about the state of Florida. We're actually really advanced and cutting edge about this. We've been leading this since, I believe, 1989. The Florida Supreme Court said this. There is no bright line light switch of you have capacity or you don't. It's not as a blanket black or white thing. It is a spectrum. It is nuanced. And so, for example, someone with an Alzheimer's or Lewy bodies dementia diagnosis, I know a lot of you are familiar. You're all caretakers. I'm dealing with this with my grandfather now. It runs in my family. I've dealt with it numerous times. My grandfather has full capacity in the morning, full conversations. We can debate politics. We can talk about the economy. 3 o'clock rolls around. He confuses me with my uncle, various things like that. In the morning, as an attorney, I can say he would have capacity to sign a legal document like a power of attorney. In the afternoon, he probably wouldn't. Just because someone has a diagnosis of a dementia-related condition does not necessarily mean that they are incapacitated to the extent that they don't understand what a legal document is and that they can't sign it. That is why I implore everyone, not because I am one and it's good for the business, I implore everyone to speak to an attorney about powers of attorney and healthcare surrogates, specifically an elder law attorney, because they're able to make that judgment call that can save so many families a lot of heartache and a lot of financial costs down the road by meeting with that individual and saying, whether or not that person has capacity. I'm sure Victoria has too. I've met with clients in the morning who I have said they cannot sign a power of attorney, but a few days later, I've met with them in the afternoon and they've had full capacity because of, sundowners conditions. Now,
Max, let me, if you don't mind, because we're running short of time, let me interrupt real quick. So Phil, hi. And just real quick, because I think part of Phil's question went to what to do when you have a recalcitrant bank.
Right.
So the bank.
I was getting to that part.
Yeah. Okay. Sorry. So banks can't just arbitrarily reject powers of attorney, Phil. So they have to have a valid reason. They can request an affidavit from an attorney on the validity of the power of attorney if there's any question on maybe witnessing or notarization or something like that. That goes for an out-of-state power of attorney. So if a local bank has an Oklahoma power of attorney and they're not quite sure if it's valid under Oklahoma law, because states have parity with each other. So a Oklahoma power of attorney should be validly used in Florida and vice versa. But the bank can request an Oklahoma attorney opinion that the principal or the agent has to get, by the way. So the bank can request it, but the agent has to go get it from an Oklahoma attorney that says this is a valid power of attorney. Once the bank gets that opinion letter, either from a Florida lawyer for a Florida power of attorney or an out of state, that's it. We're done. The bank has, it's held harmless. They have everything they need. There's nothing else to do. If the bank still refuses, then guess what? The lawyer is going to be getting all up in their face, and there's going to be probably a lawsuit or a threat. And most of the time, it's just educating the banks. They have a lot of compliance issues, regulatory issues. And the best thing we lawyers can do is get on the phone, usually with their legal department, their compliance folks, and just explain to them that this is fine, there's no problem, blah, 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 blah. And we can usually work it out. But sometimes it does take a few steps before we get to that kumbaya.
Yeah, and Phil, what Victoria, Mary, and I often have to do if talking on the phone doesn't help, we send what's called a nasty lawyer letter, where we explain how the law applies, why it's valid. But yes, there are times where you really need to speak with the banks, and Victoria may disagree with me on this one, but I actually don't get that upset about it, because it also means that even if they're being overly cautious, the bank is still being overly cautious. I'd rather them be overly cautious and overly protective than not care at all. So it might be annoying and certainly frustrates me all the time, but from a more optimistic perspective, it's nice to know that some of the banks are looking out for their customers too.
Awesome. Thank you both so much. This is very rich information. And again, I want to remind all the attendees that this packet of information, matter of fact, Max has already sent this to me, so it will be included in the post-conference packet that you receive next week. So
Sure.
Thank you, Max and Victoria, for your time today.
All right.
Thank you, everyone. Have a great day. Thank you for having us.
Awesome.